Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's start in Oklahoma City. I don't understand this one either. Well, let me give you the facts, pretty short facts. Paramedics from AMR and a fire truck responded to a seizure patient. You have a long list of facts on the website and the blog, but I'm going to make it very simple. He's seizing, and then he's, I think, post-ictal, and as probably everybody knows on this blog, post-ictal is you're pretty much out of it. And for some reason, they jump on this guy and handcuff him. And these are the firefighters, not the cops. And when the cops get there, they ask for the handcuffs, and I guess they handcuff him. And he, I'm not making light of this. It's almost a George Floyd type situation. And I have no idea of races or anything. I'm just saying, they're holding him down and he can't breathe. And then he stops breathing and he's handcuffed or hogtied. I'm not really sure which, but in any event, he is definitely restrained forcibly, according to this, and dies. So I got nothing there on why this happened.
I mean, one of the things we got to understand, we're getting the plaintiff side of this. We're not getting necessarily the city side of it, and which is typically how we roll with what we've got. So the plaintiff has laid out the case. I'm not buying that somebody is just having a medical emergency and all of a sudden firefighters just jump on them. That doesn't make sense.
Agreed.
So I'm thinking that there's got to be some sort of behavior that's precipitating the firefighters feeling the need to restrain the person. And, afterwards, who knows if there's the police on scene, who knows what the body cam footage might have picked up or what bystanders might say. But the reason why this case interests me is, and I put it in the blog, is that we're seeing many, many more cases since George Floyd's death. We're seeing many more cases of fire departments being targeted in these lawsuits, whether it's because they're getting physical. Most of them are because the fire department are getting physical with them. Some are ketamine related or sedation related. Right. Others are where the fire department didn't do a thing. They get called to the scene, but as part of government being there, they're alleging that the fire department failed to intervene. So there's a broad range of these. I have the numbers here. I think I got 62 total cases like this.
Wow.
Only 9 prior to 2016. Now, my cases go back to the 1800s. The earliest case I've got is somewhere around 1860. And not a lot of cases back then. I don't mean to suggest, but there's 53 of them have been since the death of George Floyd.
Yeah, and we've covered a ton of them on this vlog where they're physically restraining. We've had some really good discussions here. Forgetting the fact this is alleged for a second, it's interesting how they try to sue, right? Because here they're alleging Fourth Amendments. I didn't see if they alleged other things like flat out assault. I'm shocked that this is all they're alleging is a Fourth Amendment, which is violation of search and seizure. So normally when the government acting as the government, and here they focus on were they acting as law enforcement, I was surprised that mattered versus, right? Because that was narrowing. Now you're not just government. We're going to talk more about this to our listeners. I know I'm confusing you, but they allege that my right to be free from search or seizure, in this case, seizure, which would like an unlawful arrest, right? The right not to be detained without probable cause, etc. They allege that by this assault, which makes sense, alleged assault, which makes sense. And then the judge kicks it on the basis that throws it out on the basis that they weren't acting as law enforcement when they did this. Have you ever seen that? I've never seen any holding like that.
Yeah. They're starting to kind of dissect what we're doing versus law enforcement. So if we're helping law enforcement restrain someone, Okay, for example, we're administering ketamine so that they can get a suspect under control so they can arrest them. We're acting sort of as an agent of law enforcement. Whereas when we're administering ketamine for medical reasons, okay, or we're administering care for medical reasons, then that's different. And I think that's good for us. I think in a negligence action, and I know we haven't talked about negligence action, I think in a negligence action, it's not so big a deal. But when you're dealing with Fourth Amendment, and the issue is, are you seeking to apprehend this person? Are you seeking to arrest them? Or are you seeking to get an incompetent person to medical care? Because an incompetent person cannot consent or decline medical care. So if we determine the person doesn't have capacity, then there's a medical reason for putting them in restraints and getting them to the place. It's not a law enforcement activity. It's a medically related activity. And some of this, Brad, I see you look at, some of this is because attorneys are starting to make the argument. Back in the 60s and 70s and 80s, if the attorneys didn't make that distinction, the courts weren't going to come up with it on their own. So I think attorneys today are making those arguments that they weren't making before, necessitated by the growth of these cases. I'm sorry.
Right. And no, it's like, and I think the red herring, maybe, if I was to use the court's view, is the handcuffs, right? If the patient had been restrained with soft restraints that, and I don't know in this jurisdiction if it's allowed, but that were allowed to be carried by the ambulance, and some jurisdictions allow soft restraints for the protection of a patient, right? And seizing, maybe not postictal, but seizing heroin, I've seen it, but soft restraints, there probably would be no question. Look, you're not, you're doing this for medical purposes. Here, I think what the judge basically says or assumes is just because you use handcuffs, which are from the police and probably only available to the police, does not mean that you are acting as law enforcement. I don't know if I personally agree with that, because, and I would have argued it this way. I would have said that you used a procedure and a technique not available or allowed to paramedics or EMTs and definitely firefighters. You brought in the tools of law enforcement, and I would have said, so you're acting outside your capacity as paramedics and firefighters, so you must have been acting as something else. So what else were you acting as? And it seems to me when I use the police's tools, I must be acting as law enforcement. Now, fine, but you take a little bit different view, which I happen to agree with, which is, okay, but what was your purpose? What was the end goal? Was my purpose to effect a citizen's arrest? Or is my purpose to protect the patient from himself? I didn't maybe have soft restraints or other means available, so I asked the police for theirs. Okay, I could see that. It begs the question, though, and I don't know the answer to this. Can the police, if the police were first on scene and they arrive to a patient, let's say, who's in harm to himself, not others, but harm to himself, maybe he's trying to grab a knife to slit his wrist, something like that, and they handcuff him, is that acting medical or is that acting as law enforcement? So you got to get, same way, it's got to be evaluated. And I don't think that the police would be deemed to be acting in a medical capacity. It wouldn't be a Fourth Amendment violation, right? They're protecting him to himself in a different reason. They're not, he's incapacitated anyway. They're not restraining his liberties because he's mentally out of it anyway. So I would argue they didn't incapacitate him, but
I think
just don't see how you're
my friend Jack Ryan focuses more on police. I should give him a call and see what he see if there's a line of cases that sort of differentiate police behavior in terms of, are they taking someone into custody for arrest purposes, for criminal purposes, or are they taking them into custody for psychiatric, or really, and I would consider psychiatric to be medical, for medical reasons. Okay. But at any rate, in this case, it seems like the court felt that what the medics were doing here did not trigger Fourth Amendment concerns, and that also, in addition to that, they also felt that they were entitled to qualified immunity. Which the qualified immunity defense, you don't get into the merits of the case. If someone has qualified immunity, then even if they did violate their rights, even if there was a technical violation, you have immunity, so they're going to get off the hook, for any potential liability. And so the court kind of gave really two reasons for its findings, but essentially said that the firefighters are going to be dismissed from the case, and the case is going to continue against some of the other defendants, but the firefighters are out of the case, which is, I think, is good news for our friends in Oklahoma City.
Yeah. No question. And look, I'm surprised, and maybe there's more, but I'm surprised that it appears they only allege these two causes of action. And look, you wouldn't necessarily allege assault, because then you can't get to the city, because they would say, well, assaulting somebody is not in the course of their duties, so the city's not liable for it. I get why they may not have said some other things. Normally you'd see this happens all the time, breach of policies, a Monell kind of, where this always happens and the city doesn't care. Maybe they didn't have that. I don't know, but this is a really interesting case for any time a firefighter or municipal EMT restrains anybody. And I'm curious if there are other cases going the other way, that restraining somebody, could be non-medical at some point.
We got some cases. We got some of the ketamine cases, in particular, Aurora, Colorado, and that whole mess up there is really focusing on the apprehension. Like, when are you apprehending someone? Are you administering ketamine or using restraints so that the police can apprehend and arrest someone for a criminal act?
We saw that at the playoffs. Right.
The attorneys are getting better at making these arguments. And I think that's part of it. But again, the reason why this isn't a straight medical malpractice, really a negligence action, wrongful death action, which is, I think, when things like this happened 20, 30, 40 years ago, they came up as a wrongful death negligence action. And now they're coming up, as a civil rights, is because it's so difficult to hold government liable between sovereign immunity, tort immunity caps, and other public duty doctrine, a number of other different liability barriers that people would have to prevailing. So I think many people, particularly attorneys who regularly sue police departments, usually will go after those 1983 type claims, and that's what we're seeing. And not that this is new. What we're seeing is fire departments now getting named in these 1983 cases that involve police type activity.
Right. And just before we move on to the next case, one of the first things that went through my mind, obviously, again, we don't know the facts, we know the allegations, but can you take away someone's Fourth Amendment rights if they're not aware you're doing it? Right. And this question has been answered. I don't remember the answer, but the question is, so if you don't know you're locked in a room, but I locked you in a room, are your Fourth Amendment rights taken away? And that's an actual case. I just don't remember where it comes from. But so if you are truly post-ictal, and look, obviously, why are we putting you in handcuffs in the first place? I have no idea. I don't get that. But if you're truly post-ictal and you don't know what's going on, does being in handcuffs affect your Fourth Amendment rights? Because you don't know you're in them. You don't know you're restrained. Your liberties aren't taken away, as I think how the analysis goes, because you can't exercise your liberties regardless. You're unconscious. But okay, in any event, they got off, and I think this is a very, very interesting line of thinking that people. This is not an invitation, firefighters, to start handcuffing people.
No, and I think the opposite. My advice to firefighters now is, when you are going on a run to assist the police, you've got to be very careful in terms of what you do. You can read the case and you can hear some of the comments that the firefighters allegedly told the person, and how those can be spun against you. But there was some comments that were made that found their way into the lawsuit, and our antenna's got to be up when you're going on a run with the police and you're applying restraints. You've got to be very careful, and you need to document, do a very good job of documenting. This is not just another run. This is the type of incident that can lead to litigation very quickly
And the end
in
of
the
your
event
career.
that something happens. Yeah.
Yeah. And what really bothers me about this is, look, we all know one absolute truth. Cops want to be firefighters. So don't act like a cop, because now you're just saying, see, firefighters want to be cops. And we know that's not true. So let's not give the cops any reason to make them think that we want to do their job.